For delivery of judgment, item 1, WBC 4946 oblique 2017, Saken Ali versus Union of India.
This repetition is dismissed.
Item 2, WBC 4545 oblique 2018, Hajera Khatun versus Union of India.
This repetition is also dismissed. So some typographical errors we have to correct it.
For judgment, item 3, WBC 2609 oblique 19, Abdul Hussain versus Union of India.
This petition is dismissed.
For judgment, item 4, WBC 5034 oblique 19, Sona Bhanu versus Union of India.
In this, we found a very disturbing feature. The tribunal never discussed the two witnesses. We did not take into record the witnesses examined and the documents exhibited. There was no discussion. We are setting aside the impugned order and matter is remanded back to the tribunal. The petitioner is required to appear before the tribunal on 30/5/2026. Take note of that, otherwise matter will proceed ex parte.
For delivery of judgment, supply item 47, WPC 7748 oblique 19, Tara Bhanu versus Union of India.
This petition is dismissed. But in this case, while making a type copy, a part of the Assamese version was withheld. We have taken exception to that. So the typing was not correct.
For judgment, supply item 48, WPC 75/26, Ohema Bibi versus Union of India.
This petition is dismissed. But in this case, some typographical errors are corrected. We uploaded after some time. Yes, any mention are required to be made?
My lord, I beg to mention item number 42, my lord. Orders matter, my lord.
42.
Yes, my lord. There is an IA, my lord, for extension of time, my lord. And my lord, I would like to withdraw this IM and file a case.
Both sides are presented. Prayer made by Mr. S.A. Ahmed and counsel for the applicant. Is permitted to withdraw this application with liberty to approach again. According to this interrogatory applications and dismissed from liberty as appealed. And the main case is 2023. Say, give it after 2 or 3 weeks. 3 weeks. The main case, which has a representative, is transferred.
Obliged.
May it please your lordship, I beg to mention item number 3, lordship. Kindly matter may be adjourned for the day, lordship.
No, please
I
wait.
say-
This is 2019 matters. No, 2019 matters or prior to that, we are adjourning. So we has the record.
Next week, any date, lordship. SC Bishop is not
You'll have to
feeling
wait.
well,
We
lordship.
can't help it. You'll have to wait.
May I please your lordship, I beg to mention item number 11, lordship. This matter may be kindly adjourned for today, lordship.
They are made by land council. This council. Okay.
Lordship, I beg to mention item number 9. Kindly pass over matter of the 9.
Give the same date.
May I please your lordship? Lordship, I beg to mention item number 8. Kindly adjourn the matter for today, lordship.
21. Same date.
Match with Joseph, I beg to mention item number 36, my lord. Can it be recommend any other address, my lord? Today I just not feeling well.
You have to wait. This has come by order.
By
Somebody
order,
made a mention.
respondents have mentioned, my lord.
We don't know. Once it is by order, we'll have to take it up. We'll have
But-
to wait.
Recommend only first half recommend, second half I will try to appear, my lord.
Yes, please, Lordship. I mentioned the item number 27. The required sum for documents is not delivered till now. 1 month is 2 weeks is necessary for collect the documents also.
2018 matter.
27.
You have to wait. Up to 2019, you are not adjourning without looking at the records. You have to wait. Yes, next.
May please, your Lordship. I beg to mention item number 20, Lordship. Zideka is out of station, Lordship. Can the matter may pass over for the day, Lordship?
20, no, you'll have to wait. This is 2017 matter. Please wait.
For motion,
Lordship, I beg to mention item number 13, Lordship. We have to file a reply, Lordship, in this case, Lordship, but till that we could not file, Lordship. So
Well,
1
this
week
is-
time may be allowed, Lordship.
This is, we had required the affidavit to be filed.
Yes. Yes, madam, delay on the ground of delay, we want to file a
Yes.
objection. So 1 week time maybe to be filed.
In time order, yes,
Which is represented, the affair made by the Journalist Standing Council for the FT and border matters. Further 1 week's time is granted to the state respondents for filing their affidavit. List on, we take after a week.
In time order is there. In time order was what, alia order.
Think about a past tense.
for motion, item 1 with 2.
This matter, my lord, notice yet to be. Notice yet to be issued. My. I fix it for admission hearing, my lord. Today, my lord. May not be taken up today. Next week, any day. I'll set to Monday. Second वाला ले देना था सेकंड वाले पे सिस्टर्स हां अन्य का मुझे सच का इन ओपन टू दी कॉपी को कर दो कैन कॉपी कंट्रोल मेरा फिल्म नॉट अच्छा Both are connected, one entity. Deeply. No.
Item 3.
Made physiology. Next week, Lordship, any date.
Good for this, yeah.
Lordship 30, 30, 30.
Here made by land council to the petitioner. Accordingly, on the prayer made by land council for the petitioner, so that is fixed on a date convenient to the learned council. Comma. Not first row. Next, list on 30/4/2026.
Obliged. Lordship.
For motion, item 4.
Yes,
My lord, here record come, and I am sorry, my lord, there is some defect in the annexure. And voter list, my lord, complete type copy has not been given. Well. So if you also permit me, we furnish the complete type copy of the voter list.
which voter list, just as
Your lesson kindly see on page 22. 21 is the transfer because all names are not typed. And similarly, page 24, names are not understood. So I file and put the correction petition, my lord.
The original date.
The original is there. If you also allow it, then I have no problem.
in fact, we have no issue with that SMS, reading of the SMS version. If you are ready, we can take it up. For that, we don't mind. If you want to argue, let's start. If
Yeah,
you want
fine.
another date, we will give another date.
Record come, I may be allowed to, inspector record for just few minutes, then matter fixed and, second week of May, my lord.
So is that presented? The here made by the council for the petition, the matters was adjourned today. List again on.
My lord, may I inspect the records here?
Yes, please.
I will, make the records on.
Item 5.
forensic justice matter has adjourned today. It is made clear that the petition remains certain to the next date of listing from adverse orders of the court. It's placed again on presented on the listing.
For motion, item 6.
May please, your lord.
Yes.
Impugn order is at page 20, my lord. My father's name appeared in 1996. Total list, my lord. Page 16.
Yes.
Then my father's name appeared in the voter list of 1996 at page 60, my lord.
Is your speaker on? We are using your voice. Yes.
At page 60, my lord.
60.
My mother. 30. Aswar Ali. Again, 1970, my lord. At page 62.
Page
62. 62.
62.
Then again, 1975, my lord. At page 64. And NRC details 1960 at page 66. And my name appeared in 1997, voter list at page 68.
Yes.
My name appeared, my lord, in 1997 at voter list at page 68.
Yes.
A certificate issued by the Gauhati member in favor of the petitioner at page 76. You are the examined member.
You don't have a voter list along with your parents.
My lord,
You don't have a voter list with your parents.
parent, authorized. Father,
Is there a voter list of you along with your father or mother? Which one?
well, Jammamundi is there, my lord. At page 84.
Yes, please continue.
My lord, written statement at page 32.
Page
32, 32, 32.
32.
My lord.
It is your written statement.
It is submitted. With the evidence of my lord at page 42. My lord, 77.
Lordship, I'm trying, Doctor.
This is the answer.
Oh, yes, Lordship. Cross.
Numeral data.
Cross has been taken, Lordship. On that side of it. Instead of paper, yes, Lordship. You're unable to read the record in 5 minutes, that means there's something wrong. This, page 77, this clause is not even available in the record. And look at the order sheet first. Thirteen six 17.
Okay. The opening is present today along with his counsel, the
Statement is recorded
uh,
as DW2, DW2,
DW Pro.
correct?
Yes.
Now this Gauhati DW3.
Yes.
And the DW2 is an evidence by some relative of the petitioner. That is available on record. We have put up a flag. And that part of the cross-examination is not even here. This cross-examination at page 77 and 78. Don't know how you have got it. Not there in the record.
Yes, 77 and 78.
The repetition. Let me ask you to read.
Okay, yes, yes.
That is not there in the record because we could not find it. Honestly, it does not say cross-examination.
Yes. Just a minute.
It's wrong.
I will take it. Sir.
You have flagged whatever is wrong. Both the flags be put.
Both parties here lordship separately. Both parties here, this Nirmal Rekha's oath is here separately lordship, but
There.
this part I could not find lordship.
No, that's not there. That's why I'm asking. Because simple matter, it may take more than 5 minutes to read the record. That means there's something wrong. Not getting it. Why you have annexed this page 77 with these writings? Why have you annexed page 77 with all these writings? It took us a lot of time to find it that it is not there. When you have this document, page 78 also. And you have certified to be true. When you get this?
Exhibit 9. Exhibit 9 number.
Exhibit 9 in the.
We are not on exhibit 9, we are on page 77. What is that document you know?
Huh?
How do you get this document and how do you, where do you file it?
It is not provided. Fine. Refund certificate exhibit now. Gauhati. Nirmal Rekha. Refund certificate of. Xerox copy dollar very nothing. Pura dollar.
Then your connection is not there. Then your connection is not there with your projected parents. Except for the voters list of 1997, but your address is different. That is a different address. This is a different address. There are, you could find 4 times your villages have changed.
An evidence taken on lordship vernacular, but it was English.
Which one?
Page 77. Oh, no.
No. That evidence is in the
Sorry,
ID
lordship.
flag.
Yes.
The wrong recording. DW2 is someone else. Traveler passed a wrong order on 13/7/16.
My lord. Kindly come to page 87.
87.
Yes. 86.
86. Sorry. This is the certificate issued by the circle officer, Buraga, Revenue Circle, issued on 9/2/2017.
Yes.
My lord, according to records of rights, the petitioner father's name imitated a plot of land 1 covered by that number 27 of Patanam, 180 of village Solmade under Bukani Buraga. Although during the year 1983 and 94, due to erosion by river Brahmaputra, the land has been totally damaged.
The entry in the record of rights is on which date? That's not mentioned. It
My
must be a 471 document, P71 document. You're not getting this anything from here.
Something else, right? Data one, that's fine. My lord, kindly come to page 23, my lord. 23, my lord.
Page 2.
Para 23, page 13, one. 13, page 13, 1, 3, and para 20. Yes, madam. Quarterly shows, my lord, there is engaged, no further matter. Shifting is only for my lord, like livelihood matter. If you erosion matter, erosion. A certificate has been issued in that context, my lord.
Each and every document lordship father says is changing lordship. Each and every document father says changing lordship.
If you clerical mistake, my lord, those documents.
If you can
are
see a
written
connection,
by an
then
individual.
this discrepancies will overlook.
Yes, no, connection is not there, lord.
But if the village changes, then you have to show that this is the same person who is changing. There's no document to it. You have proved the, what you call this, Gampura's certificate. He refers to only one shifting. And that also he says that after SMS word used is tadanta.
So,
Innocent.
So after investigation, Gampura has no reason to investigate anything. And there'll be no police record of shifting. Unless you have absconded and the police in some report will say that you have absconded. There will be no police report. So who will write a report? Who will investigate?
No, lack of knowledge, my lord.
No. You can't say Gampura has lack of knowledge. He's issued you not one. The same Gampura has issued you 4 certificates. In the record you will find 3 is exhibited, 1 is not exhibited. And in every certificate the version changes. Two certificates he does not give any reason. Then he improves it. He improves to the extent showing that there was an investigation. What is the post? The author is of the document. Sorry, we are not finding any connect. There is only one photo space which connects you with your mother. With five, mother, father, and children together, 1997. In rain.
At page 64, madam.
See?
64.
No, that is only Aswar, son of,
Aswar Ali,
you are not there.
Jamila Khatun.
Petitioner.
No,
Aswar is-
Jamila Khatun is a mother. Jamila Khatun mother.
It's okay, but your village changes thereafter. In 1966, your father is 32. In 1970, he is 65. In 1975, he is 41. In 97, he is 65.
This even said well not, but those documents are not written by an individual man.
So just we don't know.
This is clerical Mr. Miller. This certificate is issued by the authority concerned member.
You see, I don't know the experience in villages because I've never been in that village. But yes, in my house also, a lot of times the enumerators have come. So what is this? We give them the details. They write it, they give us a copy, and then go away. You can't say that they have written wrong. If they can give me a, what you call a carbon copy of what he has written, everywhere they will be doing the same thing. I'm not sure in villages what they are doing, but in my residence, whenever they have come, they have given me a slip. Yes, Mr. Sharma.
My lord, petitioner is no way connected, lordship, and lordship, if you see the document, lordship, in 1966 document, he is 35 years, lordship, 32 years, and again, lordship, is 1970, he is 65 years, and after
1976.
lordship, Again, Lordship, in 1975, 3 cases, decreasing Lordship up to 41 years. This case 77 refers to shifting. It refers to the voter list of 1956. You've seen that? উপরতে উল্লেখ করা সানমিয়া দেউতাক 1966 চনৰ 60 ভোটৰ তালিকাৰ মতে চানমাৰী গাঁৱত বাস কৰি আছিল। চানমাৰী গাঁও গৰাখহনীয়া হোৱাত ব্যক্তিগৰাকীয়ে দেউতাকৰ পৰিয়াল সহ হোজাই
জিলা
জিলা জিলা দলকা থানা অন্তৰ্গত ভগীৰাম গাঁৱত থকা বুলি তদন্তক্ৰমে জনা যায়।
জনা যায়। You see, that means from 1966, from one village he shifted to Bhogiram. Then what about Borwating? That's not there.
Yes, yes.
And father is missing.
Father is missing since
Father is missing in
1975.
this, shifting of that village to
From Salmari to the other village.
Yes, Lordship.
So if the father is missing, how did he shift along with the father?
Yes.
And you see, when you try to improve, these things come to light. Otherwise, we would have noticed it.
Mm.
But now you have made us notice it. Just because you gave us too much of time with that page 77. You see, when you shift due to flood,
My lord.
will you leave your father separate and you go separately? It's not a human nature. You shifted with your father. So at times of distress, you don't abandon your father. You'll go together, but you are not there in the voters list. You have not stated when your father died. Why the father is missing in the voters list, you have not said. We will take a short break and come back.
পূৰ্বতীন গাঁওখন ক'ত গ'ল? দুটাৰ নাম after 1975 to 1997, there is a huge gap roughly. 75 to 97 roughly.
Right.
75 to 97.
75 to
More
97
than
years, 22 years.
20 years, Lordship. Between this period, Lordship, there is nothing, Lordship. So continuity must be there, Lordship, as per section 682 of the Citizenship Act, Lordship. And one another aspect, Lordship, if we see the documents, Lordship,
Continuity is there. We can't say continuity is not there. But it has been, the case has been mishandled. The continuity is there. The land document would show that. But the petitioner, he could not prove it. Continuity is there. The mutation took, you see, there's nothing, we got time when he did not, the counsel for the petitioner did not argue, we were reading the things. The mutation took place, the land has an antiquity since 1973. Mutated in 2020, 2017.
17.
Sorry, 2013.
2013.
So, 2013. So there is a continuity, but somebody must know how to prove it.
So, Lordship, if we see the document, Lordship, each and every document, there is a huge discrepancy, Lordship, and if we see the evidence, Lordship, his evidence, Lordship, মোৰ দেউতাৰ মৃত্যু হোৱা 12 বছৰ আগতে 60 বছৰ বয়সত হৈছিল. Specific statement has been made in the evidence, Lordship. So he deposed before the tribunal in the year of 2017. 2017 minus 12, Lordship, it is 2005. So in the year of 2005, he was aged about 60 years as per petitioner's person, Lordship, deposition. So, Lordship, if we accept this statement as correct statement, then also, Lordship,
When did his father die?
Lordship,
12 years.
in evidence, it is stated that মোৰ দেউতাৰ মৃত্যু হোৱা 12 বছৰ আগতে 60 বছৰ বয়সত হৈছিল. Means 12,
Which page?
2017, from record I have. Dada,
It is in his evidence.
yes, yes.
No, you read that. Please read that. I will read it. We will hear you.
Evidence of DW1.
DW1. Deposed in 1/7/2017.
In his cross-examination.
Yes, Lordship. In cross examination, he has stated.
Page 50, yes.
So Lordship, if the procedure relies on a document, Lordship, it should be appreciated as a whole. It is a subtle law, Lordship. 2000.
মোৰ দেউতাৰ ইমান বছৰ 12 বছৰ মোৰ দেউতাৰ মৃত্যু হোৱা 12 বছৰ আগতে 60
বছৰ
বয়সত হৈছিল।
But then the sentence is not clear,
It's
no?
okay, 60 years. My father died 20 years ago at the age of 60. That's what he
So
wants to say.
12 বছৰ আগতে that it will be
17 minus 12 is 2012. Sorry, 2002. No, 12 বছর
So if
2005.
2005.
Right.
And Lordship, as per his evidence, father died in the year of 2005.
5 voters list you see, his father's name was not there.
No. Right.
After 1975, 1997, then 2005.
Mean the
26. 77. So,
17.
28, 17.
2817.
Okay. In respect of his mother also, he made this statement, মোৰ মাৰ মৃত্যু হোৱা 10 বছৰ হ'ল, মৃত্যুৰ সময়ত 55 বছৰ বয়স আছিল।
And one more thing, Mr. Sharma, the voters list where he appears along with his father, mother, was in connection with Gauhati.
Yes, yes, sir. Gauhati.
She's nowhere there
No.
in the
In Phugiram.
Ahura certificate.
Yes, Lordship. No, dear Lordship. So,
Is the Gauhati? Did we need a Gauhati?
there is a lack of link between Boruating, Phugiram Gaon and
Salman.
Salmar.
what D.
One now.
Mm.
And you post salary of about 46. So he died in salary round. नहीं एक more data on the Mr. Sharma, we were not able to make out one word. In page number 50, you see, before you have read, he died 12 years ago.
Would deotar this word Sharmari gaon hoisile.
It
Sharma.
is taking some-
48 lines from above. Just above the this
Yes, Lordship.
More
মোৰ
data.
জন্ম ফাৰ্মাৰী গাঁৱতে হৈছিলে, মোৰ দেউতাৰ নাম
Before that, the line.
what is that word? More deotar
জন্ম
Janmo.
জন্ম
কলমাৰী গাঁও
জন্ম শালমাৰী গাঁৱতে হৈছিল। মোৰ দেউতাৰ নাম মৃত আছৰ আলী আৰু মাৰ নাম মৃত জামিনা খাতুন।
জহুৰা
লৰ্ডশ্বিপ
সুবিধা
1975 voter list is of Jamila Khatun, not Jamena Khatun. 1975 voter list, Lordship.
Please omit very, we
Yes.
don't see it very seriously.
I think Lordship in WS Lordship mother's name is not given.
Hmm?
WS mother's name is not given, Lord. WS.
Reference is 32.
WS Lordship is totally silent, Lord, in respect of her mother's name.
Sorry, we missed you. What do you say in his written statement?
Written statement is totally silent in respect of his mother's name, Lord.
His father's death,
Mother's name,
mother's name. Okay, okay.
My another submission, Lordship. You found a big hole in your case, Mr. Gugoi.
My lord,
There's a big hole in your entire case. Never give us more time than we need it to read the records. Everything gets demolished. Once you give us an opportunity. When did you shift to Bhogiram village? Can you tell us?
and my lord.
For evidence, land.
You can bear my evidence.
Please respond to us.
When the petitioner was dead, I'm
When
coming.
did petitioner shift to Bhogiram village? No. You get it? Yes, when? 95. 1995. 1995. Because Lordship, from evidence, I am reading মোৰ দেউতা তেওঁৰ মৃত্যুৰ 10 বছৰ আগতে শালমাৰী গাঁৱৰ পৰা ভোগীৰাম গাঁৱলৈ মোৰ মাৰ লগত আৰু মোৰ ককাই বাই ভনীৰ লগত আহিছিল। Lordship evidence part, Lordship page number. Lordship page 50. Last part, Lordship. Here he has said, Lordship, মোৰ দেউতাৰ মৃত্যু হোৱা 12 বছৰ আগতে 60 বছৰ বয়সত হৈছিল। That means he was died in the year of 2005. And Lordship, last paragraph, তেওঁ মৃত্যুৰ 10 বছৰ আগতে ফুলমাৰী গাঁৱৰ পৰা ভগিৰাম গাঁৱলৈ মাৰ লগতে মই আৰু মোৰ ককাই বাই ভনীৰ লগত আহিছিলো। That means if father died in the year of 2005, then 10 বছৰ আগত Lordship, that means Lordship in 1995.
In Bhogiram village,
Yes,
Bhogiram Gaon.
2005. Now,
1995, Lordship.
1995.
Yes.
At page 53, my lord, at para 11, my lord, the in evidence, my lord. I came to Bhogiram Gaon along with my parents when I was 8 years old. My deceased parents came here for
No,
purpose
18 years.
Oh, 1 8. The evidence of the petition.
So if we read page 53, you were in 2021, you were 49 years. So if you deduct from 2021, 49, your age, year of birth would be 1972. 18, at the age of 18, you went to this Bhogiram village. So it will be 1990,
19.
along with your father. If you are in 1990 in Bhogiram, then you are forwarding what you call total list of 1997 when you were there with your parents goes big hole then.
And I think Lordship, these persons are not same in one person. Because Lordship 1997,
1% then.
his age was 35.
Well, you can't say that I did not know when I write 18 years. What is your own case? Declare very.
Again, after 1997, he says
The 1997 voters list of voting goes, that goes case fails. Heard. Mr. J.C. Gogoi Learned counsel for the petitioner also heard so for respondents. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated (25/11/2020) passed by page 21. 20 and 21 both will get. By which the petitioner, namely so-and-so, was declared to be a foreigner who had illegally entered into the territory of India, within bracket Assam, on or after 25/3/1971 from the specified territory. Next. The learned counsel for the petitioner has submitted that the reference was bad in law and that the petitioner had filed his written statement denying the allegation that he was a foreigner, and in support of his defense, the petitioner had examined himself as DW1 and had exhibited 9 documents No. So it something is wrong. Something is wrong. Please match it. You have the records?
Yes,
No, first come to the writ petition.
yes.
In writ petition, page 41 is the handwritten evidence. This ends at para 12 ends at exhibit 9. Correct?
Certificate of Gabra.
Huh. And page 42 again is a type copy of the evidence. Here we have 11 exhibits at paragraph 14. Please check out which is right. Just check out. Huh? So there is a mismatch, page 41 and then type copy. We proceed ahead. Just give a underline. We can change it. And the petitioner had examined one Subed, S-U-B-E-D, Subed Ali as DW2, who was the cousin brother of the petitioner. And he had examined, he had exhibited eight documents as exhibit 12 to exhibit 19.
It is written statement option.
Hmm?
Written statement, handwritten. Written statement,
Ah.
this is not evidence.
Okay, so that will be 11.
Yes,
In evidence, it will be 11.
yes.
11, 9. Accordingly, it is submitted. It is further submitted that the petitioner had also examined the Gabra, the author of exhibit 9 as DW3. Accordingly, the petitioner has proved all the documents to show his link with his projected parents and to prove that he is not a foreigner but a citizen of India. Next, it is submitted that the name of the petitioner as an elector is reflected in the voters list of 1997, 2005, 2010, and 2014. And due to that, the petitioner, along with his parents and other family members, shifted to Bhogiram Gaon, Bhogiram, next word Gaon, G, for livelihood. But you have found that cross-examination of DW3? Is it
No,
there?
no,
No,
no.
it's not there. Because we are desperately searching for it. If you can come to page 13. of the litigation para 23, last three lines. In the instant case, the Gauhati appeared, deposed, cross-examined, leaving no room for doubt. So that cross-examination we are trying to see.
One by one, I have checked, Lordship.
No, it's okay. I mean, we are not,
Yes, yes, Lordship.
we are not disbelieving you, but still, once this statement is
Again,
made,
I am
it is our duty to check it.
Again, I am.
Sometimes they keep it in the top, just after the order sheet.
Yes, sir.
Some deciding officers keep like that. For the submit that the Indian opinion has been passed on the basis of the church, overlooking the feelings and documentary evidence. Accordingly, it is submitted that the said opinion dated 25/11/2020 finds interference is court. Next paragraph. Per contract, the learned standing counsel for the FT and border matters has submitted that the pleadings and evidence and the documents do not tally, which do not we are not telling, we'll write a good word for it, huh? Telling, T-L-L-Y-N-G, telling, and does not show a consistent stand of the petitioner. So it is submitted that though the petitioner projects that his father was present in the votages of 2005 and name of the petitioner along with his projected mother also appeared, but as per the statement made by the petitioner in his cross-examination on 1/7/2017, his father had died 12 years ago at the age of 60 years. Therefore, it is submitted that the presence of the father of the petitioner in the year 2005 ought to be there. But his name does not reflect in the votages of 2005. 2005 is exhibit. Is exhibit number 6, exhibit 6. It is submitted that in the contrary, in the written statement, in para 11 of the written statement, the petitioner stated that he came to Bhogi Ram Gaon at the age of 18 years. The affidavit in this case was sworn on 7/1/2021, and his age was 49 years. And accordingly, the date of birth, the year of birth of the petitioner would be 1972. And if he was 18 years when he shifted to Bhogiram Gaon, the year of shifting would be 1990. Accordingly, it is submitted that exhibit 6 in light of the evidence has to be held of a unconnected person. So moreover, it is submitted that in view of the said evidence, said pleadings and evidence, comma, makes the entries in the voters list of 1997, within bracket exhibit 5, as doubtful. Because the village mentioned in exhibit 5 is Borwating, P-A-R-U-A-T-I-N-E. And there is no readings or evidence regarding shifting of the petitioner with his parents from Bhogiram village, where his presence should be there from 1990, to Borwati, to have his presence recorded in the voters list of 1997, within bracket exhibit 5. Accordingly, it is submitted that the finding recorded by the learned tribunal appears to be a correct appreciation of the documents, and accordingly pays for dismissal of the petition. This is the facts we have declared. Finding will make it see we say write the order then. But so and so the arguments are concluded, judgment is out.
Again, I have said problem.
Hmm?
Again, I have said.
It's not there. This dictation, please record the documents exhibited, page 22 and 23 of the writ. 22 to 24 of the writ, exhibit 1 to exhibit 19.
Yes.
The documents exhibited are as 1, 2, 3, 4. It is here.
For delivery of judgment, item 1, WBC 2641/19, Zohura Khatun versus Union of India.
The petitioner is dismissed.
For motion, item 7,
Move legal office. The petitioner died on, my lord, 16/11/2024, my lord.
So their family members want to impeach? No.
My lord?
Do their family members want to impeach themselves?
Yes. Family member.
Hmm?
No, he's having the sons and daughters.
Do they want to impeach themselves?
No, my lord.
No. But there will be consequences. Please tell him, Mr. Sharma, the consequences.
I have,
You have told him. So that you have death certificate? No.
Yes.
Huh?
Yes, sir.
There are consequences of the opinion. Heard Mr. J.C. Gogoi done it counsel for the petitioner and so for the respondent. The learned counsel for the petitioner has produced a copy of death certificate of the petitioner issued on 10/12/2024, stating that the petitioner stating that Sirajuddin son of Abdul Jalil, ABDUL, Jalil Munshi, MUNCHI, and late Jamila Khatun, KHATUN, had died on 16/11/2024 at Sardar, 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 next word Gaon, Doboka, Hojai. Next. From the query of the court, the learned counsel for the petitioner has submitted that is instructed to say that the family members of the deceased petitioner do not want to impeach themselves in the proceedings. Full stop. Next, the learned counsel for the petitioner aware of the consequences that would follow the opinion dated 6/8/2020, passed page 23, passed by Sultan. Next paragraph. Be there as it may, as the legal representatives of the petitioner do not want to impeach themselves, this petition stands dismissed on being abated on the death of the petitioner named Muhammad Sirajuddin. Next, the registry shall send back the records of the tribunal along with a copy of the order to be the part of the record. And we said that tribunal.
Item 10 for motion.
Made to the inferior in page 107.
Suleiman, you are trying to project in this case your connection with your grandfather, whom you have traced to
I have
1953 or 55.
Directly, she has not connected with his.
Huh?
She has directly not connected linkage, not established with father and
No,
only
but-
Gaubula.
But the,
Gaubula certificate established, and apart from
no,
that,
but look at her evidence.
I mean, her father obviously evidence in favor of the prisoner.
Come to page 99.
Page 105,
No, come to page 99
page 9,
or 100, whatever.
1999. 99. Oh, sorry.
99 is the type copy, 100 is the bit illegible copy. Page 100.
Yeah,
The
yes.
answer to the court queries, I cannot remember in which year my parents shifted their residence to Chata village. My father was born in village Balarkari in the 1955. My mother's name is so-and-so. My grandfather's name is Nasir Nasa. I have not submitted any document as proof that Iman and Iman is the same person. The grandfather had landed property in Baratari village. At present, the said plot is under my possession. There are no landed property in the name of grandfather in other villages. So that connection, how have you proved? This last part of the landed property being in your name. We are reading the page 100 and 101 because the last three or four words in that page 101 is missing in a type copy.
The connected place is the next page of 100.
No, we have seen that. That's why we are reading that. In your type copy is not there. You see, here you have said there is no landed property in the name of my grandfather in other villages. That has been wrongly typed here in page 99. Other villages is left out. It makes a different meaning. Page 101. These last four words you have missed out in the typing.
Present said plot of land under my possession. There are no landed property in the name of my grandfather in other villages.
So in other village, you have missed it 99. It will make a different meaning.
Military village.
You have not been able to see the mistake. You have not been able to understand the mistake.
Look,
Come to page 101 again. There are no landed property in the name of my grandfather in other village.
Lordship.
Other village is not typed in page 99. So 99 will carry a different meaning. If your grandfather did not have land, how could you inherit? Simple. It carries a different meaning. Block 50. I could see it because I have a bad habit of reading. And then you come to page 104, your type copies. And 106 in this in the brief. About 40 years ago, we shifted our residence from Bharatari to Chata due to erosion. I have patta land in Bharatari. About 40 years ago, my father expired. The plot of land in village Bharatari is still under the name of my father. But here you say that you have inherited the land. So contradictory evidence. The said plot of land is under the possession of my brother Kasimuddin. So it's a different story by different brother. So then there is another part of the case. Come to page 117. If your father died 40 years ago, the tribunal is giving this interpretation. Page 117. First part, the by letter dated so-and-so informed the tribunal at number so-and-so were deleted from the voters list of 1985. So during verification, the voters list, the authorities have said that your name of your father was deleted in voter list of 1985. That be so. How could he vote? This makes the entire protection in the case incorrect projection. Then your only link is that certificate, Kambura certificate. Mr. Suleiman, the only link is the Kambura certificate. Now, Kambura certificate page 117, last about 10 lines. If the OPW2 is not maintain any population register in his village and also not got any population register, then on of which he has written the certificate that Proceedi was residing in village Chata, as he was not the village headman at the relevant point of time. Put it in the admission column, Mr. Sharma. And Mr. Suleiman, there are these documentary evidence, the exhibited documents. We'll ask you to prepare a list of the contents of the documents. If it is a voter list of 1966, how many voters are there? You prepare a chart of the contents of all the exhibits. Mr. Sharma,
Lordship.
in this case, you will also have to assist us because you see, come to this page 111.
Lordship.
First thing is, it is so small that very difficult to read for me.
Lordship.
It is so small font that it is difficult for me to read.
Yes, yes.
Page 111. Now look at the marking of exhibits. It is in a paragraph form. I'm not able to follow it. Which is exhibit 1? What is the entries?
Yes, yes.
Next page 112. The exhibit starts. Fourth line, exhibit 1. Now the entries are there, then annexure 1, after 10 lines, you get exhibit 2.
Yes.
Become difficult for us to follow. So put it in the admission column. Yeah. Do it after 2 weeks. What says the represented? Respect to others past earlier, the records of the traveler is received, some of the requires examination. Accordingly, report will be inclined to issue notice returnable on so and so. Next paragraph. The learned counsel for the petitioner shall prepare a list of exhibits in tabular form and indicate the contents of those exhibits. As well as the bullet points of his submissions without any elaborate discussion. Next paragraph. List the admission column on
19th of 28th of May.
21st. Any bullet point of your argument you can also put down. Don't give elaborate write-up. Bullet point of your submission and then the list of exhibits with contents of the exhibits.
Item 12.
So can you see last order and there is a delay in filing this requisition. And my lord, in boom order, you must look at this page 58. Actually, if you look at this page 61, last reason you look in notice is page 61. Page 61. Summary, my lord. Yes, that's right.
Yes, page 61 we are there.
The summary it is mentioned that in the faculty, reference OP is son of that Bajaruddin. Notice are issued and returns served accordingly. OP had inspected share including report of inquiry officer that is where his father's name is clearly written as Bajaruddin. That this is in the village Sodohari, yes, Spencer. Despite the above fact, without assigning any reason, OP came up and had contested the reference as the son of Bajidullah sir. So I am the son of Bajidullah sir, not Bajaruddin. In a reference, my father's name has been written as Bajaruddin. And my name also appeared along with my mother in the Buddha list of 1985 and subsequent Buddha list. My father died after 70.
Lord, Different. Okay. Okay. Other things are similar. Other residential address and other things all are. Yes, doctor. Mm. Mm. Also answer. Therefore, that finding, there are two findings. Number one, that Basitullah and Basiruddin are two different persons. Then it says your evidence is rejected. Thirdly, it comes that even Basitullah it is not. You're able to follow what I'm trying to say. First is that Basitullah and Basiruddin are two different persons. Then he examines the document, rejects for the, then says that even Basitullah is not good. So the inquiry is against whom? They are two separate persons. They are two separate persons. Then the proceeding will be other. It can't be the proceeding. Yes, doctor. You examine this. Because in records, everywhere it says Basit. But the inquiry officer everywhere is because the sorry, not here. In the inquiry, it refers to Basiruddin. You see this? Evidence would have framed
The wording differently. It could have said, well, the Pasarudin and Basarudin, we accept that CC has come. In fact, then they are same and then we decide.
Yes,
That
okay.
existence of two people don't come.
Yes, okay.
Now the travel with that many has make it two people. Try everyone it is Basil.
But if
The employer might be take it up after some time, after some days.
not,
So that is the only point. Let's article it. Next one. The pair made by Mr. G. Sharma, Leonard, and negotiate for the FT and border matters. The tribunal's report is handed over to him for perusal and to address the board on the next date of this thing. Next one. List on. It goes after 2 weeks.
after two.
And we're giving you that record.
Not.
With
In the meantime, I will be protected, madam. In the meantime, I will be protected. I am not protected. I will appear before the SP, madam.
So you'll not be deported. The Learned Counsel for the petitioner, Mr. JMS, Learned Counsel for the petitioner pays for bail, which is posed by the Learned Counsel for the FT and border matters, considering the position made in the description. Then it's time to take bail out of this to the satisfaction of Superintendent of Police, border.
Borpeta. Borpeta.
Then
Borpeta, my lord.
this continue. This comes with
Hello, hello.
Item 14 for motion.
see you here. Is that? With your expression, and whether you won or you lost or the results are not yet out.
Last month I was so busy in the
No,
election.
no, what is the election result?
Election result, tomorrow will be starting, counting will be from tomorrow.
Tomorrow. Because your expressions were not there. Face for expression, that's why we asked you. They're a bit out of touch, that's why.
My lord, for some period, my lord.
Okay.
Question. If the last audit dated 23 March 26, respondents will have to file the objection.
Oh, yes, objection. Yes, Mr. Sharma. Okay.
Objection.
On delay, you have to file an affidavit.
One, four.
This is a opinion of 2012. You took time, Mr. Pang took time last week.
Lordship.
To file objection.
Oh,
Are you filing it? You are not filing it.
not filing, lordship. I think it was not filed, lordship. 1 week time may be allowed, lordship.
Because the petitioner is at Matia Gwalpara. She has some urgency then.
1 week time maybe allowed, Lordship.
Is that represented? On the prayer made by Mr. J. Pang, G. Sharma, and its negotiation for the FT and border matters. 1 week further time is granted to the FT and, the Home and Political Department to file preliminary objection in the matter. Next para. The interim order passed on 23/3/2026, not to deport the petitioner. Without order, the court stands extended till the next date of listing. Next para list on. Next para. Mr. Sharma, can you communicate by downloaded copy to this Matia?
Lordship.
Hmm?
So department, Lordship. So Home and Political Bill.
We next, as the petitioner has been taken into custody and is presently at transit camp Matia Gwalpara, we request the Learned Standing Up for the Home and Political, sorry, for the FT and border matters to send a download copy of this order to the Home and Political within the Secretary's Department, so that the order can be further transmitted to the superintendent. Transit camp Matia Gwalpara. Next para. The meantime, moreover, the petitioner is also, the family members of the petitioner is also granted liberty to produce a downloaded copy of this order to the superintendent, Transit Camp Matia Gwalpara, to pick the order to the notice of the party. This counts well. You also can give a downloaded copy.
One extra copy, Lordship. One extra copy during the course of the day.
Item 15 for motion.
Please, Your Lordship, minute. Yes, Lord, the petitioner is Joygun Nessa, my lord, for Your Lordship, my lord. And as far as, my lord, the documents are concerned, my lord, she had exhibited, my lord, only 3 numbers of documents, my lord. The voter list of 1965 of her grandfather, my lord. Some, my lord, mistakes are there in the name and spelling mistakes are there. And that is at page 21, my lord. And there is a certificate of concern, Gauhati, that was also exhibited, page 20, my lord, annexure 1. See that 1965, 1970, and then Gauhati. Then Gauhati. In fact, my lord, the land documents were there, my lord. Those could not be exhibited. She did not appeal. The tribunal, first you will have to file a review petition on the. Yes, without that. Not on that point, my lord. Even, my lord, the father has come, he has deposed in favor of the, my lord, his daughter, my lord, the proceeding, my lord. And the concerned Gaubura also, my lord. He belonged to the same village, my lord. He has specifically said that he has personal knowledge, my lord. And he had also, since he was there, my lord, all along, my lord. The deposition of Gaubura is also there, my lord. But you know the law. Well, I think collectively you have dealt more cases than we have. I hear them. still a learning. Oral evidence will not be sufficient. If we go by the minute, we can at best give you liberty to withdraw this and move the tribunal for a review on this ground, but on our part, the criteria becomes very difficult. And I will, my lord, withdraw this petition with liberty to file a, my lord, petition, to file a review petition before the concerned tribunal. Lordship will kindly make this much observation, that I am trying to, I'll be projecting my case before the concerned tribunal by filing a review petition there. My lord will kindly make that observation. And liberty should be granted. Mr. Sharma? It's otherwise the recent order 2025. Yes, recent order. 9/9/2025. So it is some delay, but still give liberty. After that, we'll entertain. Yes. Decision to record as a second timely for us. They can have the recovery from the three documents. The overhead definitions and overhead definition is certificate. Whatever definition is. And then record same that the person was. Is a secondary review petition. That much only. No. But this is that how much learned from the petition and so have responded. By filing this petition, Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 9/9/2025, page 70. Asked by so-and-so in case number so-and-so, case number so-and-so, by which the petitioner was declared to be a foreigner of post 25/3/1973. Next paragraph. At the outset, the learned counsel for the petitioner has submitted that while receiving instructions, he came across, he was informed that the petitioner has several more documents which in support of her Indian citizenship, the Indian citizen of the petitioner, Joygun Nasa alias Joygun. However, the said documents were not brought on record before the learned tribunal. Accordingly, he prays for liberty to withdraw this writ petition and to approach the learned foreigners tribunal. By way of review. Next. Although the learned status for the appeal border matters has supposed the prayer, considering the nature of submission made, the prayer is allowed. The petitioner stands closed on withdrawal with liberty to the petitioner to approach the learned to approach the foreigners tribunal at Nagaon. By filing a review petition, next paragraph. It's clarified that the court has not entered into the merit of the case. My lord,
For motion item 16.
Maybe. Well, there is a dilemma in episodes of court, my lord. Resolution was, my lord, delivered on, my lord, 8/3/1922, my lord. My lord, I have explained the reason, my lord, my lord, paragraph, my lord, 19, page 15, my lord. What had happened in this case, my lord? The name of the petitioner is, my lord, Anwara Begum, my lord. Notice was served to her as, my lord, Amela Khatun. My lord, in her WS as well as in evidence, he told that her name is Anwara Begum, but this was not believed by the criminal, my lord. And finally, my lord, the tribunal held that Anwara Khatun and Amela, my lord. Lord, from initial case, my lord, she was stating that her name is Anwara Begum. My lord. Lord, within, WS at case, my lord, 45, except 12, my lord. Yes. He has disclosed about her, my lord, parents, grandparents, and paternal uncles, about children. So that is not, the learner table not held that Anora Begum and Mela Khatun is not one and same person. So not her advocate matter understand that you have no problem because you are not Amala Khatun, you are Anora Begum. With this hope, she did not have to. She went to her original place at Baba district, but last the month of December, he got a call from her relatives that border police is serving. Then, she
Your statements are contradictory. You see, come to page 17. You say that so many things you say that the lawyer told you something and you thought that nothing would happen. Correct? Now come to paragraph 21. After passing of the judgment, you apprehended arrest. How can these two things stand together?
he was informed by her relatives.
We understand. If you are not informed that, then you don't apprehend arrest. At 21, you say you apprehend arrest after passing of your opinion.
On this line,
And that goes back to 22, when the opinion was passed. Contradictory stand.
well, I am sorry, for this line, sorry.
It's open, but keeping it open. Note. And there is some that is transferred for the petitioner and so for the respondent. That's fine. In this writ petition under Article 226 of the Constitution of India, the petitioner will send the opinion dated 8/3/2022, page 92, passed by so-and-so in case number so-and-so, SP reference number so-and-so, by which the petitioner was declared to be a foreigner of post 25/3/1971 stream. Next paragraph, in view of the inordinate delay in assailing the said opinion, keeping the issue of maintainability open on account of the maintainability on account of delay and latches open, issue notice returnable on so and so, extra copies within 2 days, call for the records. Next, the prayer for bail shall be considered on receipt of the tribunal's records. Next, in the meantime, if the petitioner, namely Anwara Begum alias Musammat Amela Khatun, is apprehended, she shall not be deported out of the country without order of the court. Next, the petitioner shall cause production of a certified copy of the order before the Superintendent of Police, Baksa, to bring the order to the notice of the said authority. Next, list on so and so. 18th of May.
Bless me.
Item 17.
What is the original? Here,
Page number?
42. Expect no? It has appeared I may just have written the statement. Thereafter was not appeared, and case was bundled for several years, several days. And therefore again notice was issued, but she has not received notice, or one relative received a notice. But in the meantime,
Third,
well, I disclose one thing. Paragraph 9 of my petition,
paragraph 9 of
9 of my petition. Another proceeding, now in the meantime, petition arrested on 2/11/2025 on the extent of a W warrant of arrest and PNA issued in a PRC case. And that case arising out of a judgment and order dated 7/9/2017 passing another application number 571/2016. That was expired. I have no knowledge about that case, but I contested the earlier case, my lord. And on the basis of that, I filed a writ petition here. And that's how 9, I annulled that judgment. my lord.
page,
Page 50, 50. This is a hand in a suspicious place.
third, Mr. J. Ahmed and counsel for the petitioner and so and so for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 31/10/2023, page 42, passed by so-and-so in FT case number so-and-so, ERO reference number so-and-so, by which the petitioner was declared to be a foreigner, and petitioner was declared to be a foreigner of post 25/3/1971 stream. Next, the learned counsel for the petitioner has submitted that on two 11/2025, the petitioner was taken into custody pursuant to ex parte opinion passed by the learned member of a foreigners tribunal number 8 at Gauhati in page 50.
No, PSC case was registered.
That's okay.
This is the
Ex parte opinion. Ex parte opinion, 7/9/17. I've said that. Ex parte opinion dated 7/9/2017, passed by page 50, passed by so-and-so in case number so-and-so, ERO reference number so-and-so, by which petitioner was declared to be a foreigner of post 25/3/1971 stream. This topic is further stated that against this said opinion, the petitioner has filed a writ petition, being, WBC 50/26. Next part. Be that as it may, in view of the inordinate delay in setting the given opinion, keeping the issue of mental ability open, issue notice returnable on so-and-so, extra copies within 2 days, all the records. Next paragraph. In the meantime, as the petitioner has already been taken into custody, pursuant to opinion dated 7/9/2017, passed in, referred above, the court is inclined to provide that till the next date of listing, the petitioner, namely so-and-so, alias so-and-so, alias so-and-so, shall not be deported out of the country without order of the court. Next, family members of the petitioner shall produce a certified copy of the order before the where she's there. She's where?
detention camp at Matia.
Transit camp Matia Gauhati. Bring the order to the notice of the said authority. Next, list on so-and-so.
After 2 weeks, matter will be listed along with that matter.
No, we are not tagging it right now.
Because in that case also, that interim order has been filed. In that case also, that interim order has been filed. This is a matter of take.
No, without the records being coming, we are not tagging it. Otherwise, no case will proceed.
Fine.
It may be. If it comes thereafter, we can tag.
Right.
For motion, item 18.
May please, Lord. Opinion start from page number 117. 150. Under Article 226 of the Constitution of India, the petitioner has said, the opinion dated 10/2/2026, page 117, passed by so and so in FT case number FT so and so, RIMDT case number so and so, by which the petitioner was declared to be a foreigner post 25 in 1971 stream. Next paragraph. Issue notice returnable in 4 weeks, extra copies within 2 days, call for the assignment records from the concerned tribunal by the following email address of the learned tribunal. Next paragraph. The prayer for bail is opposed by the learned standing counsel for the FT and border matters. Next, considering the projection, mainly the writ petition, 10 days time is granted to petitioner to take bail out of this 5,000 to the satisfaction of Superintendent of Police Border. Which place? Borpeta. Next part, list after 4 weeks on the seat of tribunals.
Okay.
Supply item 49 for motion.
I may be also. Impugn order is page 49. Here in this case, a father examined as DW2 minor, but as per tribunal order, there is no any finding and has not discussed anything about the DW2 minor. And further, the DW2 was not cross-examined by the state authority. I have found this. A father. Yes. Yes. I'm not going,
Page 50.
not discuss about, DW15.
At page 46 is his evidence,
Yes.
and the tribunal referred that he exhibit A and B was not examined by the OP.
And no, my lord, as per tribunal order, my lord, the gift it, my lord, which is exhibit 6, has not been put. And that is the finding of the tribunal. But the tribunal did not give any finding on DW2 Miller, and also has not discussed anything.
No, definitely, your affidavit is at page 46.
Yes.
In page 46, what you have done is the DW2 has
Yes.
exhibited only two documents, certified copy of 2010 voter list
Right.
and a voter identity card.
Hmm.
He makes a statement that at para 11 that he has gifted,
Yes, gifted.
correct?
Yes.
But that's only an oral statement. It's excluded by operation of section 91 of the Evidence Act.
Milord, at the time of adduced evidence, Milord, the gift it, Milord. Who would have any objection, raise any objection?
It's not a question of objection. You say that he's against his father, there was a reference of gift deed but not discussed. That is your statement.
Yes.
But that statement is,
Entire evidence of the DW2, Milord, has not discussed. Not only, Milord, give this, Milord.
everything else is an oral evidence.
Yes. Oral evidence, Milord, is admissible when the opposite party by respondent side has not raised any objection.
Mr. Sharma can give you two judgments immediately.
Yes, Lordship.
Yes. And Milord, in this case, Milord, I have found, Milord, and a tribunal simply pass this good order without discussing anything.
You see, even we may not like to take this as correct, useful piece of evidence. Come to page 46. Page 46, the name of the DW2 is Hazrat Ali,
Yes,
correct?
yes.
Now, come to page 48.
Hazrat Ali Mondal.
Yes.
Hazrat Ali Mondal is the title, Milord, which is explaining the.
You see, we don't know this person personally. So we don't know whether it is title or not, but you give evidence as so and so.
Which is explaining the page 48, para 13, Milord. Hazrat Ali, and also somewhere my name is recorded as Mondal, is the title and my dynasty.
Mr. Chaudhary, we are pleased to see you after lot of days.
That privilege to come to this court, man. It's second half, but I think another division is there, man.
We express that privilege of the court that we have seen you.
No, what it is my view.
And you see, your stand would not be admissible for two reasons. Number one, you take a plea that Mandal is your dynasty,
Yes,
correct? If there is a dynasty, then there must be some continuity, correct?
yes.
Now, please come to that page 46 again. Hazrat Ali, you forget to write your dynasty. Then son of late Darog Ali, against your father also you omit dynasty. Now, if you keep on omitting your dynasty, kindly explain how will we consider that there is a
Milord, in the
dynasty?
voter list of 1970, Milord,
So therefore,
here is also Mondal is.
no, that's why you see, it is your case that it is a dynasty.
Yeah.
If it is a dynasty, then how you can omit in your own name the prefix of your, so the suffix of your dynasty? That means you are creating two people, and therefore the Mandal who is there as a voter, and you are disconnected. if there is a dynasty which is going on, dynasty must mean what?
It is a title, my lord, more than
No.
title, my lord. It is a
Dynasty would mean some antiquity. When we read history, against whom we use the word dynasty? You see, you are appearing as a witness in 2017. So you don't have a continuity uh, of your dynasty even after that. You have not shown any voters list where your name continuously appears as Mandal.
Yes, my
So
lord.
only two voters lists are given, 1966 and 70,
Yes.
and you say that you have a dynasty.
And subsequently, my lord, they are shifted their residence, my lord.
But dynasty will not vanish with the changing of village.
The voter list is prepared by the, my lord, authority, my lord.
No, no,
And sometime
you are
Mondal
taking a
appeared
different
and
plea.
sometime.
You are
only
taking a
Gauhati
different plea.
appeared.
Please tell me, Mr. Ahmed,
Similar.
your name appeared in any voters list?
Yes, my lord.
Correct. Now the enumerators come, what do they do when they come to your house?
And sometime, my lord, in the voter list, my lord, father name.
No,
is only
forget that.
favorised.
In your case, what has happened?
Yes.
When the enumerator enters your home,
Enumerator never entered my home, my lord.
never entered.
Yes, never entered me. Never entered. That's why, my lord, my name is a discrepancy, my lord. My name is a discrepancy. And my father name also discrepancy, my lord.
Oh,
Sometime
you
Babur
are-
Ali, sometime only Babur. And sometime, my lord, my name is Abdul Motin, Martin. Sometime Abdul Mutin. Sometime Abdul
And in
Mutin
the
Ahmed.
digital age, you did not correct it.
Every time, my lord, we have filed the
But we don't
form.
know. This experience is new to us. That the
But,
enumerator did
but
not
that
come.
is the discrepancy is going on.
How will you give the house number? In the current voters list, how will you give, how will they give you a house number?
House number, my lord, when, my lord, we have collected form, my lord.
No. Always by chalk, they will write in the front of your house, house number. If you come for a morning walk with me, I will show you many houses where the house numbers are still written. Even after all this rain, after all this, you will still find house numbers marked in many houses which are exposed to weather. At random, you check up any village. We'll make it a point to go there and check it. If in any village the house number is not given, take at random. Any village. You see, please come to page 43. Mr. Sikdar and Mr. Chaudhary, we may not be able to take up other matters because we'll have to rise early today.
My case is another division.
Hmm?
Another division is,
Oh, acha, that,
so whether it will be there or not, if not, I will go on.
no, that we'll have to sit for that. That's why we are rising. We'll be rising early. It's not division bench, it's a single bench, I believe. It was a single bench. Single bench.
No, not single bench, my division, another division bench is there.
Oh, that is sitting singly. That's why.
Yes.
It's a delivery of judgment.
No, my item is 64 miles. Huh? Or 53 miles.
8 million method.
Oh, this division.
This is for this bench.
This way.
We will not be able to take up. Because
Then
it's
my
right
lord.
for the single bench.
Then, may I go ahead?
Yes, yes, that's why we are probably.
Yes, so,
We don't want seniors
so
to.
fix my lord. In this case, your lordship has to impose some fine, my lord. Affidavit was not filed. This is the case.
I won't remember that much.
Anyway, my lord.
Unless I open the brief, I will not
My
remember
lord,
anything.
well, next week, my lord, any day, next week, my lord.
Okay.
Obliged.
You come to page 43, paragraph 6.
That after attend my eligibility in the.
29 years, about 29 years ago, I was married to so and so.
Yes.
Now, this is 2017. 2017 minus 20 would be 1997. Correct.
Yes.
So at that time you would be in the voters list.
Her name is appear with the husband's attachment. Voter list is available.
No, it doesn't match. You see, because I already showed you paragraph 6. Next line, you see your voter list of my name is recorded in the year marriage after 89.
Yes.
89 cannot be. You said, okay, 29 years ago. Okay.
29
29 years ago. Okay. In 89. Okay.
अच्छा अच्छा ठीक ठीक।
In the written statement, is the name of your brother available? In your written statement, is the name of your brother available?
Yes, Mr. Written statement is page. Page 35.
Right, that we have read, but is your name of your brother available? Have you written the name of, disclosed the name of your brother in this written statement?
No. 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 Miller, a similar facts and circumstances Miller. One case is Domila Khatun Miller, where the Miller, the tribunal, learned tribunal did not discuss the DW, E and 4 Miller. For that ground Miller matter remanded back the tribunal.
You don't see that it is not.
In this case, Miller, I am praying for a similar pair to remand the matter back to the
It comes
tribunal
back.
to,
Because we see that there is a discussion.
discussion, Mr. Miller, in this case, Miller, the learned tribunal did not any whisper about the DW2 Miller.
It's not required. It's not required. Please tell us, you write an order and show us what to write. You see, we make a discussion. You see, in this case, we are trying to just understand if there is any iota of link to show you to be an Indian citizen. Otherwise, we would have closed it long back. Come to page 40. The SMS version is at page 41.
Yes, yes, yes.
You don't know in which village the house of your father is. You submitted voters of 66 and 17 and don't know the name of the village. I do not know the name of the village in the voters list where your name appears. I do not know the name
Yes.
in which year my name appears in the voters list. Your English typing is wrong because here
Particular chairman, 41.
photo talika to naam uthise na jano. Then you say, good Devta Madrasa Para Gaon. Ki para?
Madrasa Para.
Huh?
Madrasa Para.
Madrasa Para thake, moi na jano.
It's going to take a minute.
You see, even with that statement, we are still trying to find out.
Part Miller. How I will verify that part Miller. And here is also Miller in the top Miller, age is mentioned 20 years. In the page 41 Miller, vernacular page, age is mentioned 20 years. That is also wrong.
You see, few things we are omitting.
And this is also wrong.
The age and name we are, at this moment, we are not even asked you. It is only when the things do not match, then we try to find out about the discrepancy. If the entire storyline fails. Have I started asking you in any case, you have argued before this bench, starting with the discrepancy, have I asked any question?
No, Miller.
Starting question?
No, Miller. I'm agree with you.
It only happened when your storyline fails. Then this discrepancy come to light. So you see what happens is that you want to know more? In your written statement, you refer to voter list of 2010.
Hmm.
But it is of your
Husband.
matrimonial village. But then in the evidence, you don't give that. Your father comes and exhibits a voter list of 2010 of his family. It contains the name of your brothers. And that is why we asked you whether your brothers' names are disclosed. If it is not there, then question comes at the admissibility of 2010 voter list, which is beyond pleading.
In the written statement, my lord, I'm not giving any blame, my lord, but not specific anything, my lord.
We are not on that. We are telling you.
Our petitioner is illiterate, my lord. She does not know what is written in the written statement as well as the evidence, my lord.
Your father is your brother.
That is the problem, my lord. She is an illiterate lady, my lord. That's why, my lord, what written by the youngest council, my lord.
You don't know, you can't.
That's why, my lord, happened in this. In this written statement also did not mention any about the siblings, my lord. Only bus, my lord.
We don't know, sir. We find it very difficult to
Hmm.
question the ability of the council. We can't do that. Yes, Mr. Sharma.
Yes, Lordship, Lordship, if
And which is the case you are referring that it was
Jomila Khatun. Jomila Khatun.
Jamila Khatun.
Yes, my lord. I am giving the details, my lord. Eric Mara, mulai dari Jomila Khatun. Itu file kas. Yes, I am giving.
Okay.
Yes.
If Lordship gives it an oral statement goes, Lordship, there is nothing to link with it, with our projected parents, Lordship. Gift it, if your Lordship, this gift it was registered prior to 3 days before filing the written statement, Lordship, 26/9/2016. And written statement was filed on 29/6 to 29/9/2016.
Itu kas. Mulai ada.
Page 28, Lordship. Registered on 26/9/2016. And 29/9/2016. As Lordship already pointed out, there are no names of our brothers and sisters, Lordship. This is also Lordship relevant that Lordship regarding this gift deed portion, Lordship, there is not a pleading in respect of this gift deed, Lordship. So one can, Lordship, there is no pleading that no pleadings that the father of the proceedee gifted a plot of land to her Lordship. Although it was gifted 3 days before filing the written statement, Lordship.
No, my lord.
So, Lordship, it is settled law that, Lordship, one cannot go beyond pleadings, Lordship. And Lordship, In this regard, Lordship, Rosminara Begum's case, I want to rely 2017 4 GLT 34C. Two thousand 17.
I,
Paragraph
Pediatric আছে,
Page 37.
pediatric আছে।
Oh, yes. Okay. Yes, yes, perfect. Let me. Yes, Lordship, I have seen, but Lordship, Lordship has already pointed out the evidence, but Lordship, মোৰ দেউতাৰ নাম হজৰত মণ্ডল, মোৰ দেউতাৰ ঘৰ কোন গাঁৱত মই নাজানো। মই 1966 চন আৰু 1970 চনৰ ভোটাৰ তালিকা এই গোচৰত দাখিল দিছো, সেই তালিকাত মোৰ দেউতাৰ নাম কোন গাঁৱত আছে মই নাজানো, মোৰ নাম কোন চনত দেউতাৰ তালিকাত উঠে মই নাজানো, মোৰ দেউতা মাদ্ৰাছাপাৰা গাঁৱত কেতিয়াৰ পৰা থাকে মই নাজানো। So he does not know anything in respect of her father, Lordship.
যেগুলো পাইছা একটু কোড নষ্ট দিব লাগিব, কাগজ দিব। গৰমৰ গেছ দিতে হবে। itu mau gitu, itu kita mau pertarungan itu, ada tuh, ada tuh, itu sama itu sudah kan itu betul. Jadi kita kan tidak boleh
So Lordship. So Lordship, otherwise Lordship, he was totally silent in respect of her brothers and sisters, Lordship. Lordship, Rosminara Begum versus Union of India, 2017 4 GLT 346. 4 GLT 346, paragraph 25. 27 also important. Lordship, written statement is the basic statement of defense of a proceeding before the Foreigners Tribunal, keeping in mind the mandate of Section 9 of the Foreigners Act 1946. It is incumbent upon the proceeding to disclose at the first instance itself, that is, in his written statement, all the relevant facts, especially within his knowledge, having a material bearing on his claim to citizenship of India. Material facts pleaded in the written statement are thereafter required to be proved by adducing cogent and a reliable evidence. It is also tried that a party cannot traverse beyond pleadings made in the written statement. So, Lordship, regarding oral statement, Lordship, what I am relying to judgment, Lordship has already pointed out. To 2023 GLT 347. 2020 3 GLT 347. NUR Nur Begum BGUM para 6 Lordship. And here mother came and deposed Lordship. And another is Lordship WPC 4020 of 2017 on same footing Lordship. Here father came and deposed. ASIA Asia Khatun KHATWN. Here also para 6. Yes, Lordship. Statement of DW2, Amiruddin, who claimed to be the father of the petitioner, cannot be relied upon in the absence of any documents showing his relationship to the petitioner. In this, we would observe that a proceeding under Foreigners Act 1946 and Foreigners Tribunal Order 1964, the evidentiary value of oral testimony without support of documentary evidence is solely insignificant. Oral testimony alone is no proof of citizenship. The evidence of DW2 thus falls short of being considered as cogent, reliable and admissible evidence, so much so to establish linkage of the petitioner to him. Lordship, item 50, Lordship, record is with me, Lordship. Madam Burma has briefed me about this case, Lordship. I have seen, Lordship. Yes, Lordship. Otherwise, Lordship, I have seen the LCR, no discussion of the evidence part, Lordship. It's not there. So, Lordship may do the need to Lordship. So, concerned SP Lordship may direct the in the order, Lordship. No pass order in this regard, Lordship. Lordship may pass order. I have returned back the LCR that may be noted, Lordship.
The petitioner had examined four witnesses as OPW 1, 2, 3, and OPW 1, OPW 2, OPW 3, and OPW 4. Just give their names as examined. Herself as OPW 1. One Abu Hanifa, ABU, next word HANIFA as DW2. One Mustaqim MUSTAKIM, Mustaqim Ali as DW3, and Mohammed MD, Mohammed Harjul, HARJUL, Hawk as OPW4. However, comma, in the impugned opinion, comma, the learned tribunal had referred to the evidence of only the petitioner and referred to the and the discussions were limited to the exhibit numbers 1 to 6. However, there is no discussion on the evidence of OPW 2, OPW 3, and OPW 4. Stop. In the considered opinion of the court, the lack of discussion on the evidence of 3 OPWs vitiates the impugned opinion dated 7/6/2019. Next para. However, it may be mentioned that the Learned Standing Counsel for the FT and Border Matters has made its submissions in support of the impugned opinion. Stop. Nonetheless, as there is no discussion of 3 out of 4 OPWs examined by the petitioner, the unhesitant opinion of the court is that the non-discussion of the evidence of 3 OPWs vitiates the impugned opinion dated 7/6/2019. Next, according to the court has no hesitation to set aside the said impugned opinion dated 7/6/2019, passed by so and so and so, page 767. Next para. Resultantly, the matter is remanded back for a fresh decision by the Learned Foreigners Tribunal after considering all the evidence and materials on record, next paragraph. As the petitioner is unrepresented before this court, on where the matters were previously listed on 7/4/2026, 22/4/2026, and the petitioner is also unrepresented today, the court is inclined to provide that on commencement of the proceedings before the learned foreigners tribunal, the learned tribunal shall make an endeavor to serve notice of appearance on the respondent in such manner as it may be deemed appropriate. Needless to say that the service of notice shall be in accordance with the relevant provisions of the foreigners within bracket tribunals, bracket first order, 1964. Next paragraph, the registrar shall send back the records to the concerned learned tribunal as expeditious as possible. Next paragraph, the petition stands allowed to the extent as indicated above. There shall be no orders to cost.
Milord, item number 52, Milord.
All of those will be adjourned.
Item 52, Milord, my new motion matter, Milord. The impending order is up to 21/2026.
This is,
52, Milord.
what is the date of the opinion?
2020.01/2026, Milord.
22,
21/2026.
20,
Yes,
1/26.
yes.
Which is the page of the opinion?
Opinion is page, Milord.
Okay, 94.
Yes,
Okay.
94.
You have done the corrections?
Milord,
Amendment done.
there is no specific order, that's why, Milord, I have already read the cost title, Milord, amendment cost title, Milord. There is no specific direction,
Yes,
that's why.
there's a direction. Last date we made a direction.
Yes, Milord.
Shall provide an amended cost title in respect of respondent number 4 to the AOJ. And AOJ has stated that you have not filed it.
Yes. Milord, there is no specific order, that's why,
There
Milord.
is a specific order.
In the IA, Milord.
Yes. And in this matter also, there is an order
Yes, Milord.
because,
Monday I will file, Milord.
but there it has to be acknowledged. What says the representative? In view of the office note dated, just see the office note date. The office note dated, just check it up, huh? Office note, and so indicating that the amended cost has not been filed, some of the matters returned today. Next, the learned counsel for the petitioner. Respondent granted 2 days, 2 working days time to do the needful. Next, list as and when the amended cost is filed. 23/4/26.